Good afternoon, everyone, and welcome to today's webinar on COVID-19, the impact on construction from a legal view. My name is Anne Core and I'm Enterprise Ireland's Construction Market Advisor in the UK. And I'd like to thank you all for taking your time out today and being here. Today's webinar will be recorded and it can be accessed on our social media channels or by emailing myself or my colleague Niamh Kearney, and our information will come up at the end. And so I'm now going to hand over to Dominic Jones and David Evans, the legal directors at Blake Morgan.
Thank you, Anne and Niamh, and good afternoon to everyone joining this webinar. I believe that many of you sell goods, works and services to the UK construction sector, and that those activities have been affected to varying degrees by the Irish government's decision to halt non-essential construction activities. Some of you may also have permanent operations in the UK and may be principal contractors on UK construction sites. So in this session, we aim to touch on some of the key issues that we are seeing that are likely to be relevant to your analysis of risks arising in those areas of your businesses due to COVID-19. So I'm going to start with a brief summary of how the current UK government guidance applies to construction works, and then highlight some of the key legal issues that might arise in construction contracts governed by English law. My colleague David will then pick up on some of the practical points that you might need to consider in plotting a way forwards, before leaving you with a few concluding thoughts and addressing questions that have been submitted to Anne. And you'll expect this from lawyers, of course, but I must stress that we are not providing legal advice in this session. That's because every situation will turn on its facts and will require its own analysis. But if you have questions following the session, please feel free to contact David or I directly or via Anne or Niamh at Enterprise Ireland. So by way of slightly sobering backdrop, although official statistics are not yet available, key analysts are confirming that the steep decline that we're seeing in activity across all sectors means that the UK is clearly already in economic recession. Forecasts aren't saying how long or how deep the recession will be, but some commentators are anticipating a 2.5% contraction in the UK construction industry, and that's assuming that the current lockdown measures are lifted by the middle of the year. The hope, of course, is for a swift bounce back once restrictions are eased. And so it's important for the sector to be ready for that possibility, whilst also preparing for a W-shaped or a sawtooth recession that some are unfortunately predicting. One key issue facing UK construction at present is that there remains considerable uncertainty around how social distancing guidance is to be implemented in active construction operations. The current instructions issued by way of government guidance have been developed and finessed over recent weeks and require, as you'll be aware, that everybody stays at home, works from home, unless they absolutely cannot do that. And one of the limited reasons for travel is where that travel is required for work purposes. And the construction and manufacturing sectors are identified as sectors where such travel will be required and permitted. There are conditions, of course. People showing symptoms or living with someone who is must self-isolate, and employers are required to ensure that Public Health England guidelines on social distancing, hygiene and PPE are followed where possible. Now, each iteration of the guidance contains some variant of that troublesome where possible caveat. For instance, I've seen where it's practical to do so or where proportionate. And the Department for Business issued some sector-specific guidance on Tuesday, which is shown on the slide on your screens now. An extract is shown on the screen, and that's the firmest statement yet, requiring social distancing measures to be followed on site, again, wherever possible. So the obvious question is, well, what happens if it's not possible? And the guidance goes on to say that you should consider whether the activity in question needs to continue for the site to stay open. And if it does, you should take all mitigating actions possible. Again, not a conclusive mandatory statement. So that arrangement effectively pushes the decision to project stakeholders to determine the appropriate approach in the specific circumstances based on the relevant contract terms and health and safety obligations. And as a result, we're seeing a range of different approaches being taken. And I saw an article this morning, actually, in fact, suggesting that work might be forced to a halt by a shortage of face masks. Of course, a fundamental health and safety requirement for many trades, completely irrespective of coronavirus. The Construction Leadership Council has been leading the industry's engagement with government and seeking to offer clarity to businesses, and has set up a specific task force for that purpose. As you may well have seen, the CLC has issued various pieces of advice on site operations and suspending works, some of which David is going to touch on later. But illustrative of the current confusion is the approach to updating the site operating procedures. So the CLC sought to update those with a revised version that took a firmer stance on social distancing, and stated that where it's not possible or safe for workers to distance themselves from each other by 2 meters, then work should not be carried out. The clearest statement we've seen. But that led to an immediate outcry from significant areas of the sector, saying that their work simply could not continue under those conditions. So as a result, the CLC swiftly reverted to the less stringent version 1 of the procedures, and Build UK conceded that the updated version had resulted in more confusion than clarity. The Secretary of State for Business has written letters in support of construction and manufacturing, reiterating that work should continue where it can be done safely. So it's a fluid picture, and to add to the fluidity of it, on Tuesday this week, the Scottish Government issued guidance to the construction sector to stop all non-essential work in Scotland. And the Welsh Assembly has enshrined the 2 metre distancing requirements in law, although, again, that's with a caveat that employers take all reasonable measures to achieve it. And of course, as we said, one of the reasons for today's webinar is because the Irish government has taken a more robust and much clearer position. There is a morsel of comfort for those involved in public sector projects. So the UK Cabinet Office has issued a procurement policy note, that's PPN 0220, which proposes measures to support cash flow throughout the supply chain, including by allowing advance payments to at-risk suppliers where appropriate. One of the key conditions to entitlement there is transparency, including to demonstrate that main contractors are in fact using any monies released to pay their staff and subcontractors. And that concern about payment bottlenecks has been echoed, in fact, by the CLC in a letter today, which calls on the whole industry to keep money flowing, and warns that the calls for government support are less likely to be heeded if the sector itself can't demonstrate that benefits are going to be distributed fairly. So against that backdrop, what relief might the law provide to project participants that are not able to perform their contractual obligations due to COVID-19? Who bears the time risk? Will liquidated damages be payable if completion is delayed due to the virus? And what about liability for prolongation costs? Where do they all fall? Well, these are real issues. It is an extremely difficult, complex position. And as I've said, people are forming very different views based on the mixed messages around keeping the economy going and at the same time protecting public health. So while UK legislation or statutory action would in most cases provide contractual clarity, the advice and guidance that we have at present doesn't really. As of this week, some of the UK's biggest developers and contractors have taken the decision to close the majority of their sites. Projects worth 104 billion have come to a halt. I think that figure's as at Monday of this week. And these stoppages are hailed as morally responsible actions in some quarters, but unless they're done consensually with agreement, they are likely to raise uncertain contractual consequences. So one of the lessons to take, that we should all take, particularly us lawyers, from COVID-19 is that many construction contracts just don't provide clarity on how the risks arising from an epidemic or pandemic are allocated between parties. There's been a good deal of discussion and analysis on these points, and a lot of that is focused on the protection that would be offered by force majeure provisions, which are terms of a contract that relieve the parties of their obligations to perform on the occurrence of an unforeseen event falling within a specified category. So the first point to note is that there is no freestanding principle of force majeure in English law. It's a civil law concept that is imported into UK contractual arrangements by express drafting. So accordingly, force majeure relief will only be available if and to the extent the contract includes a clause to that effect. So where goods, works or services are supplied on the basis of a short form order with no detailed terms and conditions, for instance, then force majeure is not going to be relevant. But if you did have a clause, force majeure, we didn't use those words to have the relevant effect. But if you've got a clause, the key considerations are to establish the scope of the clause and whether the current facts fit within that scope, to look at whether the relevant circumstances are outside the control of the parties, and were not reasonably foreseeable at the points when the contract was entered into. And even if that's not expressly included in the clause, those principles will generally be implied by law, unless the contract says otherwise. You have to consider what steps can be taken to mitigate the effects of this force majeure event, and make sure you comply with relevant notification formalities, especially when notice is stated to be a condition precedent to entitlement to rely on force majeure protection. And finally, the last bullet under that heading is what does the contract say about the consequences of the force majeure event? For instance, is there temporary relief from performance? Is there entitlement to recover costs and losses flowing from the event? Or does the event give rise to a right to terminate contract? General point is that the meaning of a force majeure clause will be determined following the normal rules on contractual interpretation. The traditional approach to the interpretation of any clause that excludes or relieves liability is to read any ambiguity restrictively against the party seeking to rely on the provision. And that raises a question about whether force majeure provisions would be treated in that way, read restrictively, or whether, in light of more recent statutory regulation under the Unfair Contract Terms Act, a more balanced reading would be appropriate. And that's just one of many points that I can see falling to be examined more closely if COVID-19 unfortunately leads to disputes around the applicability of provisions like this. So given the scope, extent, consequences of force majeure provisions will depend on what the contract says, it makes sense to refer to some example wording. And let's take the commonly used JCT and NEC standard forms of contract, starting with JCT. So unless amended, the main forms of JCT contract provide for force majeure as a relevant event, entitling a contractor or subcontractor to an extension of time for completing the works. The term force majeure is not defined in the JCT contract, so those words would need to be given their normal meaning in the context of the contract. There is case law to the effect that an epidemic disease would be an event of force majeure, and that's set out on the slide there. So on the face of it, there's an argument that the COVID-19 crisis may well amount to force majeure for a JCT contract, provided the contract was entered into before the present epidemic became a reasonably foreseeable event, so before December last year. And if it was, then it's difficult to see what a reasonable contractor would have done to prepare for the consequences that we're now facing. Although going forward, of course, that reasoning is likely to become more contentious, and contractors may well be expected to be making appropriate provision for epidemics, particularly in light of previous issues, SARS, swine flu, avian flu outbreaks that have gone before COVID-19. There is a counter-argument that the JCT force majeure wording should be construed more narrowly than in other contexts. That's because the JCT contract expressly covers a number of events that might be considered force majeure type events like war, strike, extreme weather conditions, and for that reason the scope of a catch-all force majeure category might be limited. So in terms of consequences, as a relevant event, as we said, force majeure entitles a contractor to seek an extension of time, but not to claim additional costs associated with delay. That's because force majeure is not a relevant matter in JCT terminology. Also worth noting that if a force majeure event delays performance by more than 2 months, then that will give rise to a right to terminate the contract. Important to flag that the JCT wording provides that time for performance will only be available to the extent that the disruption resulting from the event, so COVID-19 here, can be shown to be the operative cause of delay to the project, and where the contractor relying on the force majeure can show that it's used its best endeavours to avoid the effects of the delay. Those points are really two sides of the same coin. So if performance is delayed because a contractor has elected not to source alternative supplies where they're available, perhaps due to cost consequences, or if it stops work to protect the workforce, but in the absence of any mandatory prohibition, then the operative cause of the delay may not be COVID-19, in fact, but rather the contractor's decision. And similarly, the contractor is unlikely to show that it's used best endeavours to avoid delay if it hasn't exhausted all the possible alternatives to ceasing work or to the delay. So we can come on to talk about some of the practical applications, but just briefly thinking about circumstances where activities in Ireland have been halted by government intervention, mitigation steps might include exploring whether there might be an express exemption available from a relevant authority to permit export of products, or exploring possibilities for reallocating supplies between UK-based projects. JCT contracts also require the contractor to give notice of possible delays forthwith, if and whenever it becomes reasonably apparent that the progress of the works is being delayed or is likely to be delayed. No time frame is stipulated, but it's good practice to issue those appropriate notices in a timely manner to show compliance with the contractual machinery. And finally, it's just worth noting that relevant events are often adjusted by amendments to the standard form JCT contract. So, for instance, the term force majeure might be defined so that an epidemic or pandemic would clearly be excluded from the scope, or to limit the availability of relief to where performance becomes impossible or illegal. Beyond the force majeure relevant event, JCT contracts also include other relief provisions that might be engaged by the present circumstances, depending on how things develop. So just to touch on a few of these, if the employer instructs closure of the site or postpones commencement of the works, that would give rise to a claim for time and to associated prolongation costs. If the UK government closes the site by exercise of a statutory power, that would lead to time, but again, not money. The provisions around post-contract changes, particularly changes in statutory requirements, might be worth exploring, as those provide that if there is a change that leads to an alteration or modification to the works, then that alteration will be treated as a contractual variation, giving rise to a claim for time and cost. I just flag that because the definition of statutory requirements in the JCT could be read as broad enough to include a change in Irish law, if that law affects performance of contractual obligations. And depending on how matters develop, there may be other trigger events that come into play, such as non-payment by the employer, leading to a right to suspend, delay in receipt of statutory permissions, civil commotion, strike action, and just a note that the same considerations around causation, mitigation, notification and amendments also apply here in the same way as to force majeure. Conscious of time, I'll just canter through a few points on NEC contracts. So in the NEC world, there is of course a general obligation on the parties to act in a spirit of mutual trust and cooperation, and to raise potential risks through the early warning mechanism to enable efforts to find an appropriate resolution in the best interests of the project. NEC addresses both time and cost consequences via a compensation events mechanism, rather than separating time risks and cost risks as JCT does. And the equivalent of a force majeure provision in NEC speak is a prevention event, and that's a compensation event. So it allows time and money, and also provides grounds for termination after 13 weeks of delay. So that's an event that stops the contractor from completing the works on time, which neither party could prevent and which an experienced contractor would not have anticipated or allowed for. Compensation events also can arise due to employer instructions or breaches, or if option X2 applies to the contract, so it's been expressly selected and incorporated, then a compensation event arises in the event of a change of law in the country where the site is located. And it's important to note that the 8-week time limit for notifying compensation events is a condition precedent to entitlement to relief in NEC 4. So finally, on legal matters, another principle that may be relevant is frustration. So frustration is a common law contractual doctrine. It doesn't require any express term in the contract for it to be available, but its application will be informed by how the contract allocates risks between the parties. So the general test is set out in the extract from Davis and Fairham on the screen there, and essentially frustration will be arguable where, without fault of either party, a contractual obligation becomes impossible or illegal to perform because of a material change in circumstances after the date of the contract, or because the purpose of the contract has been removed. Now, this is a high threshold to reach, and there's little in the way of judicial comments to assist in how the doctrine might be applied in the context of an epidemic or pandemic. Some commentators have suggested that may be because the doctrine emerged in the late 19th century around the same time as advances in medicine and removed the frequency and extent of epidemic illnesses, so these issues hadn't arisen before the courts. There is a possibly unhelpful statement in one of the leading cases from the early 1900s about frustration of the purpose of the contract, in which a judge said that he sees nothing that makes this contract differ from a case where a person has hired a taxi to take himself to Epsom to see the races, but for some reason or other, such as the spread of an infectious disease, the races are postponed. In such a case, it could not be said that he could be relieved of his bargain. So that might be something that people pick up on, again, if disputes arise, and might mean that in order to rely on the doctrine, a party would have to show that performance had become impossible or illegal. Now, importantly, performance will not be treated as rendered impossible if it's simply more difficult or more expensive to deliver. For instance, because works or services materials need to be sourced from elsewhere. The availability of frustration will also depend on whether the particular risk in question has been ascribed to either party under the terms of the contract. So whether parties have agreed the consequences of a particular event, the occurrence of that event won't frustrate the contract. For instance, because the JCT and NEC contracts contain relatively detailed risk allocation provisions, there's an argument that the parties have provided a fairly comprehensive framework for addressing supervening events. And so the scope of any frustrating event will be correspondingly limited. If the impossibility or illegality can be avoided, then performance is not truly impossible or illegal. That's a bit of a truism. But a party seeking to rely on frustration may need to show that all avenues have been explored in order to demonstrate that performance has been rendered impossible or illegal. The fact that performance of manufacturing construction activities in Ireland is, as I understand it, illegal under Irish law, may well be sufficient to frustrate a supply contract. The Irish law might be what's referred to as an overriding mandatory provision for the purposes of the Rome 1 regulation, which an English court would need to give effect to. Now that might give some comfort to suppliers and subcontractors, but it's unlikely to assist the main contractor unless they can show that there's no alternative source of supply. So an example might be where a contract specifies Italian marble, and exports from Italy are illegal under Italian law. And as for consequences of frustration, if a contract is frustrated, then the parties are discharged from their obligations from the date of frustration. And the basic position is that the losses lie where they fall at that point, but the Law Reform Frustrated Contracts Act and the common law principle of unjust enrichment may require that certain pre-frustration payments are reversed, or that monies must be paid post-frustration in relation to obligations that have been performed. So that, I believe, yes, that's all I was going to cover on legal issues. So now I'm handing over to David to pick up on some practical considerations flowing from that.
Thanks, Dominic. This is David Evans. You'll have gathered that the situation isn't terribly clear cut. I mean, generally speaking, you're going to be looking at two considerations really: that the legal position as it applies to your particular circumstances, and every case is going to be different on its facts. It's going to depend what your contract is and what it says about the position we're in. But also the second strand to consider in all of this is the impact of health and safety law on all of this. Dominic, thank you. It goes without saying that the HSE obligations and the advice given by HSE is something you've absolutely got to take into account, and you should be carrying out proper risk assessments on site and determining for yourself and discussing with your employer or the other parties involved on site exactly what the risks are and how you're going to address them. But don't forget HSE guidance on all of this, because there are criminal liabilities potentially involved if things go terribly wrong. Dominic's touched on the CLC's advice. I think I don't think it's worthwhile going through all of that now, but essentially the situation is changing on a daily basis. I suppose that the hope being expressed by the Construction Leadership Council in their statement on payments and contract on the 8th of April was that payments should continue to be made under the contract, and that parties shouldn't threaten to invoke what they describe as penalty clauses, but it should instead seek to sustain the industry. And the procurement policy notice 0220 has confirmed that public sector clients are going to continue to pay suppliers at risk due to COVID-19 until at least the end of June 2020. So essentially what the government and the Construction Leadership Council, which of course falls under the Department of Business, Energy and Industrial Strategy, are trying to do is encourage people to take fairly sensible collaborative steps, if possible, to continue working. The estimate is at the moment that somewhere between about 25% and 30% of sites have stopped, and everybody else is going. Other practical stuff you've got to think about is, having said, don't lose sight of what you've agreed to in contract. Look at arrangements for interim payments and all the payment obligations that are going to be there. There's a case reported this week which confirmed that all the adjudication provisions of the contract still apply, and again it's going to depend on facts, but I expect people will be arguing about whether there are natural justice points which are going to apply to any dispute, but try and avoid all that by getting your certificates and your notices and everything in place. And I mean, if the contract administrator isn't performing because he can't attend site or she can't do what is necessary, then communicate about that and give any appropriate notices of default. The obvious thing that lawyers always say in these circumstances are to give relevant notices, and keep full records. You know, who said what to whom, describe what's going on site, describe what you're not able to do, what you can do, take loads of photographs. If things really go badly wrong, it's those contemporaneous records that everybody's going to be falling back on. Try and negotiate with everybody involved in the project. Try and find mutually beneficial solutions. Ideally, you're going to be in a position where people are being reasonable and understand that things can't continue exactly as they were. I mean, if your guys aren't turning up to work on site because they're looking after somebody who's at home, who's vulnerable or so forth, the advice at the moment is for those people to stay at home. Well, if they don't turn up, what are you supposed to do? I'd encourage you to try and engage with people you're involved with in these contracts and just see if you can negotiate a way through it. In terms of mitigation, yes, try and, if material supply is a problem, then try and source materials from somewhere else. There are lists which you'll find on the web of material suppliers who are remaining open and those that are partially closed. Try and find alternative suppliers of materials if that's an issue. And you know, do your best to negotiate and plan your way out of this. You need to keep an eye on what's going on. I mean, if by mutual consent or otherwise, then the situation on site has meant that work has substantially stopped, then you know, you need to be clear about why that stopping of work has happened, what the circumstances are around that. You need to think about what happens if you want to resume performance, how quickly can you remobilize, and if there are concurrent causes of delay. In other words, if delay is being caused by something else apart from the virus, that could be important. And so you need to be documenting and putting on the record what's happening and why the site's actually being delayed, whether it's due to COVID-19 or whatever. COVID-19 passwords is a bit sort of blue sky thinking, as I understand it. What we're really looking at there is whether, I mean, for example, as this thing goes to its natural conclusion over the coming months, whether we might be in a situation where some people might be told that they're completely clear. In other words, that they can go back to work because they've already had the virus, or you know, that they're in some way designated as being okay to work. So you need to just keep an eye on what the government's saying about all of this and react to any changes in legal requirements and comply with them. Dominic, do you want to turn the next slide over, please? Yeah, I mean, time is going on. I think a lot of this stuff is pretty obvious. Really, keep an eye on the Construction Leadership Council's advice about all of this. If you're going to close down a site, or if the site keeps going as it was before in some way, then you've always got to be thinking about doing that, closing down, restarting, maintaining operations safely. You've got to think about security, but both in terms of site security, but the security of your own workforce, making sure they've got their PPE, making sure that if the PPE is getting soiled or is getting used, that it's replaced regularly. You've got to keep an eye on the work that's being done and whether it's being done safely. And there are continuing obligations about all of this. When you resume operations, then again, that's something you need to coordinate with everybody else in the project team. It's no good your guys turning up on site if nobody else is there, or if you know there's been a misunderstanding about what work can continue. So again, it's about communication and understanding what work is available to be done, what's required of you, and working through and planning and assessing the risk involved in getting back to work and determining what you can do so safely. there's some interesting questions about security of materials and that sort of thing. I mean, some contracts require materials that are on site and not incorporated in the works to be sort of separately labeled and identified and kept separate from other materials until such time as you've used them or put them into the actual works themselves. But you need to be clear about what the contract says you're required to do for your own materials, which might be on site, or indeed somebody else's materials that might be mixing with yours in some way. There are going to be insurance obligations to consider. If, you know, heaven forbid, the whole site's closed for 2 months, then, and you come back and, you know, surprise, surprise, it's not all there, then who's going to be responsible for that loss? You need to establish what the insurance provisions might be, where the liability and risk for loss might be, and whether anything's going to be damaged and how you can prevent that. As far as key personnel are required, well, I mean, if you've got particularly expensive bits of kit on site, and you know that you need to keep checking that it's still there and it's being you know, looked after properly, and it's properly packaged and safeguarded, then you may need to get people on site to check that. There may be wider concerns about safety on site. It's probably a sensible precaution to take to regularly monitor sites, just to check that all of the provisions you put in place to safeguard the site materials are all still there and haven't been tampered with. And then finally, just keep an eye on what the position is as far as your receipt of payments are concerned, whether you're paying other people. Insolvency is going to be a big issue probably throughout all of this. Some people are just going to run out of cash, and so far as you can, talk to people again about payment arrangements, and you need to think about what would be the case and what would happen to your materials if they're on site and the contractor goes bust. How are you going to actually recover those materials? What's the any administrator or anybody going to say about those? And if you are in a position where the main contractor is insolvent, then you need to be talking early about your claim to ownership of goods with an administrator, and if necessary, that's often where we get instructed to intervene to make sure that administrators and liquidators don't overstep the mark when it comes to materials and goods that are clearly not incorporated in the works and which are you know, which are not owned by the contractor or the employer in a situation like that. What have we got next, Dominic? Yeah, commercial discussions. It's really just a question of keeping the channels of communication open, and if you're going to agree something, then make sure it's adequately documented and appropriately agreed, and how you agree changes to the contract or variations of the contract are really some things you need to be careful about. If you're talking about contractual variations, that's one thing, but if you're going to vary the whole structure of the contract and your contract's made by deed, then you're probably going to need a deed of variation to cover your contractual position. Anticipate claims, keep full records. Well, you know, we've covered that point, but essentially you may well be in a position where you're going to be facing claims of one sort or another. Try and negotiate your way out of them. Offer mediation as a mechanism for resolving any dispute. An offer of mediation will put you in a better position further down the line. If you are in a dispute and it does end up in before a court or some sort of tribunal, the fact that you've been reasonable and have been seen to try and sort it out is going to go in your favour. Check insurance positions. I mean, you may be fortunate enough to be in a position where some of your existing insurances cover your position. I mean, the old insurance clauses many years ago now used to include force majeure provisions. Most of those have gone, but there might be other insurances that might be able to help you around bad debt and that sort of thing. But I mean, just scour your insurance policies and see whether you've got any business interruption credit insurance, whether anything in your existing building insurance or all risk policies cover you and may give you, for example, some sort of litigation risk insurance. And finally, you know, with a bit of luck, there'll be life after this, and you just need to think through how you're going to respond to this. When you're setting up new contracts, what do you want to do to provide for this sort of situation happening again? I'm sure there'll be plenty of drafting and plenty of advice from lawyers about what exactly contracts should be saying in future. But you need to probably think about the clear consequences of all of this, and look at how you might perhaps develop continuity plans and business models that might put you in a stronger position if this happens again, or as you trade out of this situation. You never know, there might be opportunities you can actually take advantage of. That's more of the general stuff. I think we've got a couple of slides at the end, haven't we, which just show the sort of things to think about. And I think really where we are now is just wrapping up and dealing with any questions. The context, as I hope you've gathered, is that the law is not certain, really, and we are anticipating, lawyers, quite a lot of certainly disputes. And when it comes to what force majeure, frustration, and all these other concepts, how they're going to impact on your contracts, what they all mean, we would expect that a couple of cases are going to end up in the Court of Appeal before we've got complete clarity about where some of this, where some of the liability for some of these problems is going to lie. So there we are. I think that's probably enough of that. And do we have any questions that we want to pick up now?
I think Anne may have one or two. Or do you want us to knock them about, Anne?
Well, I've just you've covered most of it, most of the questions that we had in, and there was just one where if one of a contract didn't have a clause in it that covered anything that other contracts would under the force majeure, but they basically just had a supply type sort of agreement with a contractor here in the UK.
Well, I mean, the starting point really, I suppose, is if there's nothing that describes the position that the company's in, if you're not covered by a force majeure type clause that anticipates the situation you're in, then you're probably you might be looking at some sort of frustration arguments, but and of course the reason force majeure type clauses are often inserted into contracts is to avoid the situation where the contract might be frustrated and the party that couldn't perform might be able to say that the contract had been had come to an end, terminated because of a frustrating event. It's really going to be case by case, and it just is going to depend exactly what has been agreed, what the facts are around all of that, and how we might be able to apply the law to it. It's terribly difficult for people to understand really what their potential position might be without putting all the facts of the case they're in to a lawyer and getting preliminary advice. And I'm not trying to drum up business. I'm afraid that's just where we think we are really with all of this.
Yeah, there was a related question, wasn't there? There was a related question, I think, that mentioned a specific contract, SPC 2000, which I think the question refers to the fact that does not have an express force majeure clause in it. So all the points David's made apply to that position. But that's a fairly detailed contract and does have a number of grounds akin to the JCT relevant events and the NEC compensation events, and it's worth having a look at each of those to see if the current circumstances fit into any of those provisions.
Yeah, I mean, certainly SPC has provisions around early warning notices and meetings in I think section 3, and then there are I believe that the parties to it have got an obligation to achieve the highest possible standards of health and safety in all activities forming part of the specialist works. You're right, Dominic, there's other stuff in there as well, where both parties potentially might be liable for injury or death of particular individuals. I think there's a change of law and change of regulation provision in the SPC at clause 18.3, I think. But that's, again, SPC, a bit like NEC, is focused on the change of law in the country where the site's located. So it's not the same as NEC, but there are those sort of considerations, and it is just going to be a question of looking at what the facts are and how the contract applies to them.
Yeah. There was another point around entitlement to suspend performance of obligations under a contract, and I think that the simple answer to that is there's no freestanding common law right to suspend performance. There is, of course, the Construction Act's right to suspend for non-payment. So if monies are held up somewhere up the supply chain, then that might be a basis for suspending. In those circumstances, the right to suspend only applies for until the money is paid. Again, might be specific contract terms on rights to suspend, but in the absence of anything statutory or pre-agreed, it'll come down to a sensible conversation between the parties as to what is the appropriate solution for a particular project, and hopefully there are strong enough relationships to allow that to happen. Anything you'd add on that point, David, about suspension?
I know. I think that's just about covered it, really. I mean, the essential point is you can't just stop work. If you're going to stop work, you've got to have a damn good reason and be able to justify it under the contract.
Yeah.
Yeah.
No, sorry, go on. I was going to link to something else.
Well, the only consideration, as I mentioned at the start, was that you've got to consider the safety and health of people on site, and don't lose sight of HSE and health and safety obligations. The two kind of run in parallel to that extent. Yeah,
absolutely. I mean, that is going to be the most difficult area of the analysis, as far as I can tell, because contracts typically require contractor to adhere to health and safety requirements. Now we're in a situation where there are changes to those requirements, but those changes are by way of guidance and advice rather than by law, which puts us into this grey area. So yeah, very difficult, and for all the reasons we've discussed, the best approach must be to have a sensible conversation and see if there can be a commercial arrangement reached. And I know you touched on this, David, in your bit, but maybe just to sum up, if you can reach a sensible commercial deal about suspending or dealing with the consequences that we're now facing, what do you need to do in order to document that deal that's been struck?
That's true. And the one final point on health and safety is, I mean, as Dominic and I, we're both construction lawyers. We're not health and safety legal specialists. But even if we were, we wouldn't be health and safety specialists. might be a set of people who are actually advising contractors about health and safety on construction sites. So, I mean, you know, if you're in an area where you really don't know what's safe and what isn't, and what you should and shouldn't be doing, then you need to be thinking about appointing an expert to advise you about health and safety on site. So at least you can be seen to have got appropriate advice about that, and you may need something to justify decisions, whatever you do with the works and whether they continue or not. I think our time's almost up, Anne, isn't it? So that might be a good point to stop. What do we think?
It is. I'm just going to conclude by saying a huge thank you to yourself, David, and to Dominic and to Blake Morgan for coming on and doing this webinar today. And if anyone who's dialed into the webinar, if you have any questions or you want any more information on today's topic, or you would like a copy of the slides, please do email myself or to Niamh. And I'd just like to say thank you for joining the webinar today. And again, many thanks, Dominic and David, and take care and look after yourselves. Thank you.